Hi, I'm Dan Chambers of Chambers Law Firm. This is episode 8 of an ongoing series talking about the anatomy of a criminal case. We've covered a lot of ground already, from the initial client meeting all the way through conducting discovery, analyzing what motions need to be filed, and developing a case theme. In this episode, I'm going to talk about a preliminary hearing. Now, preliminary hearings in California are only available if you are charged with a felony. Right? They don't apply to misdemeanors. For misdemeanors, you do not get a preliminary hearing. What a preliminary hearing is I'd like to think of it as a trailer to a movie. If you go to the movie theater, you see a bunch of previews about upcoming movies. And of course, they always show you the best parts. A preliminary hearing is kind of like that. The prosecutor just has to put enough evidence on to move the case to the next stage. It's a very low burden of proof, and there's no jury there. It's simply a judge listening to the evidence and trying to decide if there's enough evidence there to show that you committed the crime and that the elements of the crime are met. And that goes back to what I said in an earlier episode about the importance of pulling the jury instructions, because sometimes cases can be won at the preliminary hearing if one of the elements is lacking. They don't have enough evidence. So preliminary hearings are a preview to the case. So the DA typically puts on just their strongest evidence in a very condensed fashion to move your case along. Now, a lot of defense attorneys don't take the preliminary hearing all that seriously, and they don't really prep for it as much, thinking, oh, the judge is going to find enough evidence to move it along, and they kind of give it short shrift. In my view, a big mistake. Preliminary hearings can be used to lock people into their testimony, because you have to remember, the DA is calling witnesses. So let's make it, let's say it's a sex case, right? And the victim of the alleged sexual assault is going to testify at the preliminary hearing. Well, that's a great opportunity to test their memory, to lock them in on certain things that were told to police officers right after the incident occurred. It might be an opportunity to highlight that maybe their story has changed over time, and you're getting the benefit of sworn testimony where you can lock them in on key things. If it's a police officer case, you can do the same thing. You can ask police officers about what they did not include in their report. Why isn't it in there? What was their reason for not putting that particular witness or evidence in? It's, again, an opportunity to lock the police officers into the investigation they did, or more importantly, the investigation they didn't do, so that you can exploit that at trial or use it against the DA to say, hey, this is not a great case. There's all these inconsistencies. We should think about trying to resolve this case. So the preliminary hearing is incredibly important. It should be fully prepared for, and you as the client need to be an active participant at the preliminary hearing. By that I mean ask for a legal pad from your lawyer, take notes, pay attention, because you may hear things that you know aren't true or didn't happen, but maybe your lawyer doesn't appreciate that yet. They don't know enough about the story, or it's a little nuance that you forgot about to let your attorney know. So make sure you're engaged in the process. Thank you for joining us.